Hello, hello, y'all. Welcome to this presentation on the Fair Use Doctrine and copyright infringement. My name is Nicole Gaither. I'm a trademark and copyright attorney with Sage House Legal. We're going to discuss a few things tonight, like as I mentioned, the Fair Use Doctrine, copyright infringement. We're also going to understand the basics of copyrights and make sure that you have a better understanding of why these disclaimers might not work. Let's get into it. So, of course, as I just mentioned, I am an attorney. And of course, there's going to be a disclaimer because, the law. The opinions expressed in this presentation do not reflect the views of my law firm, Sage House Legal, or its clients. This presentation was created for educational purposes and to provide legal information. It is not to be used as legal advice because there is no attorney-client relationship between us. We do not have any type of agreement in place, and I don't know the specific facts and circumstances of your situation in order to apply this legal knowledge and information to them. And of course, I should not skip the fact that please do not use this presentation that I put together and basically own the rights to, the copyrights to. Please don't use it for, your own purposes or for commercial purposes without getting written approval from Sage House Legal. All right. So I know that for a while, if you opened Facebook and saw somebody with music playing in the background of some video or on Instagram or any social media platform, someone was going to have this disclaimer in or on that post. And it always states that they don't own the rights to any of the music played. And we know they don't own the rights to any music played because they're probably not Beyonce, they're probably not Cardi B or anyone like that. They're probably not a record company or publisher. So there's probably a chance that they do not own the rights to that music, and they are telling us that they don't own the rights to that music. What they're also telling us is that they are committing copyright infringement. In most cases, this, might not mean anything because usually, as the case goes with like Facebook or Instagram on your personal accounts, there, you know, there are deals with a lot of the performing rights organizations to license the music. So, like, if the music is playing in your video, there is probably a good chance that that song was properly licensed and Facebook is allowing it to be played. I've heard that people have said that they put this because it does allow Facebook, like Facebook is reading it and saying, oh, well, they put this so that they can use the rights to this music. I'm not going to have it muted for them. That's not how this is working. Like I said, there are certain songs, usually some of the popular songs, that are licensed by the social media platforms in order for you to have them in your background. So you don't need this disclaimer that it's admitting, it's basically saying like I'm committing copyright infringement, like ding 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 ding. It's like a flashing light. So of course, it seems like this disclaimer and this situation has finally you know, been picked up. Not sure if it's thanks to our TikTok College of Law students or the Instagram JD program or even my favorite, the Twitter Esquires. But I'm not seeing this disclaimer anymore. But now we're starting to use this one. I'm protected under the Fair Use Act. Again, first of all, I think a lot of people do not understand the Fair Use Act in order to, really determine if this is appropriate use of it. And second, again, the Fair Use Act is related to copyright infringement. So once again, admission of infringement and then stating this disclaimer that you think is going to save you. And we're going to talk about why it's not. So the Fair Use Doctrine is a legal doctrine, but it's also an affirmative defense to combat a claim of copyright infringement. So this means that someone is going to sue you for copyright infringement, or if they haven't already. And the fair use doctrine is your way of saying, Yes, I committed copyright infringement, but not so fast. I had a reason, and this is why. We need to also understand copyright infringement. So this is the definition from copyright.gov. And it's also in the code. So we're going to also see where it's located in the US code. But just summarizing really quickly, copyright infringement is when a copyrighted work is reproduced, distributed, performed, publicly displayed, or made into a derivative work without the permission of the copyright owner. So think of that. Like you didn't have permission to do these things from the copyright owner. So this is what is considered copyright infringement. Also, understanding what is copyright. It is the legal protection of original works of authorship that have just a fraction of creativity and are fixed in a tangible form. So this is, poetry that's written down. It can be written down on a napkin. It's fixed in a tangible form, and it's, something creative. These are things that are, creative expressions. So like blog posts, social media posts, photographs, artwork, software code. If you wrote a play, all of these things that you think of that are creative or have content are generally protected by the Copyright Act. And as the owner of a copyright, the act provides 6 exclusive rights to you. So, like, you have the exclusive rights to do this and to prevent other people from doing it as long as you have this valid copyright. So, you can reproduce the work, you can prepare derivative works, you can distribute copies of the work, you can perform the work publicly, display the work publicly, and if it's a sound recording, like if it's basically, a song with music, you can perform that work publicly using digital audio transmission. So, these are the things that a copyright owner has the right to do as the copyright owner. And again, looking at that copyright infringement definition, and this is where it's located if you want to play along at home, it is Title 17 of the US Code, Section 501A. And like I said, copyright infringement is when anyone violates those 6 exclusive rights of the copyright owner. So this means that if you copy somebody else's work without their permission, or you are performing someone else's work without their permission, that is considered copyright infringement. And again, the one thing that people tend to not realize is that the Copyright Act is a strict liability statute. And what that really means is that even if you are following this rule that someone told you that was true, but it actually turns out to not be true, you're not excused from infringement liability. Like it's not going to get you off. What it possibly could do is make you appear to be an innocent infringer, but then that just means that you probably won't have to pay the full amount of damages. Like it just reduces the damages, but you still will be liable for copyright infringement. And for some reason, this is the thing where a lot of people just don't seem to understand that if I just make some changes to this little Mickey Mouse design, that it's okay because my friend told me that Mickey Mouse is in the public domain because, it's available online. That is not the case. And as a lot of people just found out recently, we'll probably talk about this later, is that Disney does not play when it comes to that mouse. Um, they don't play with any of those characters, but when it comes to that mouse, I think they're like, you know, out there. The other thing, and I might have referenced this a little bit earlier, is this 30-second, 100 copies, two-thirds, 10% rule. Like, if I only use 30 seconds of it, it's okay. I only made 100 copies of it. It wasn't like fully distributed. It's just two-thirds of it. Or my favorite, which I do not understand and no one can explain to me, is this 10% rule. Like, if I make a change to 10% of it, it's not copyright infringement. So what's the other 90%? Help me here. This is a myth. It's still infringement regardless. Like there's no quantity of it, but we will talk about that in more detail. So, let's talk about fair use and the factors. And again, can be found at Title 17, U.S. Code, Section 107. Here is, you know, pretty much the summary of it. Um, Fair use of a copyrighted work basically means that you're using a work without getting permission from the copyright owner, but you're using it for such purposes as criticism or commentary or to report the news or to teach, do research. So some of these things are considered fair use. But again, you can't just go by, well, I'm making criticism because maybe what you're doing is not really criticism, or you're commenting, or maybe it's not really commenting. Just these are things that you need to consider, like, will another party think this is what it is? And one of the ways that you can kind of figure out, without thinking that I'm going to say it. Some copyright owners might not come after you if it appears to be fair use based on these factors, because who wants to spend that much money in court to have a judge tell them, yes, it's infringing, but it's fair use? So there are some situations where this is kind of decided like, yeah, that's probably fair use based on these things, but it is not a guarantee. So the first factor is related to the purpose and character of the use. So did you use this commercial work, or excuse me, did you use this copyrighted work in a commercial nature? Like, did you use it in order to, sell your products? Or is it on your business account to market your goods? Or are you using it for educational purposes? Like you teach in a classroom, for kindergarten, and you're making a copy of something from a coloring book. Like, was that, you know, for educational purposes? The second factor is related to the nature of the copyrighted work. Is it a creative or imaginative work? Like, is it some work of fiction? Is it someone's artwork? Or is it a factual work? Like, is it a biography? Is it a nonfiction book? Is it unpublished? And this is where we have to kind of take a pause and recognize the definition of published as relates to the Copyright Act. Publication under the Copyright Act means that something is being um, released to the public in a way where it is either sold, borrowed, leased, any of those ways of distributing to the public, where it is being featured outside of your little bubble of your house and your little, bubble of people. So for my producers or, music people, this is if you send a track to a DJ and you want them to play it at the club. Once they play it at the club, it is published. So keep that in mind. Once it is published, it's out there. It still means it's protected, but that just means that, there is stronger level of protection and, this fair use factor weighs against someone if they have taken a work that has not been released to the public, it's unpublished and got their hands on it some kind of way, and then decided to release it to the public. Like you didn't have the authorization to do that. Third factor is related to the amount and substantiality of the portion used and related to the in relation to the copyright work as a whole. So this looks at the quantity and quality of the material used. So let's say we have a 100-page book and you reprint 50 pages of it. So you've taken half the book. So that quantity, wasn't important enough for what you were doing. Like, were you commenting on 50 pages of the book? Was it necessary for you to have those 50 pages? Versus, let's say you only took 2 pages of the book. However, it's the 2 pages that are the heart of the book. For example, if it's a mystery book and those 2 pages tell you who the killer was, that's basically substantial in relation to that work. So this whole little 10% making changes or only made 100 copies or only used this portion of it might not necessarily work in your favor if those little portions that you used or you changed or you took or whatever still go to the heart of the work. Final factor is the effect of the use upon the potential market for or value of the copyrighted work. Does your unlicensed use harm the existing or future market for the copyright owner's original work? Like by you using this copyright protected work, does it affect the owner's right to be able to license it, to sell it, to make money from it because you're doing something with it? And as I stated earlier and alluded to, these four factors are evaluated by the court on a case by case basis. So there's not really a formula to say that, you used it was a creative work, but you didn't use all of it, or you only, you know, used these certain words, things like that. So it's not really predictable, is what I want to say. However, you can kind of at least see from examples of how courts have applied, and then also just looking at it, if what you're doing is going to fall under fair use. And I will tell you right now, more than likely, if you are using a song on your business page that you couldn't get access to from Instagram or TikTok, and you used a workaround to get it there, then you are not going to be protected by fair use. That's not fair use. That is copyright infringement because you did a lot to get there. Here are some examples, just so you can get an idea. This book is part of the Picasso project that this art I think it was an art gallery or like a company that's related to art. They deal with art. They put together this book. They obtained these photos of works of Picasso that another company had, took those photos, reproduced them in this book, and started selling the book. They were sued, of course, for copyright infringement, and they tried to claim fair use because they put it in a book, it was transformative, and, it was different than what was actually being used by the photos, like, it's in a book. The court looked at it and was like, "Yeah, no, this book was put out for commercial use, they were selling it, so it's not transformative, like, even though you took the photos and put them in a book." Okay, well, now what? The photos were creative, so they were protected by copyright. They were also copied in their entirety, like, they just took the photo, put it on the page, and boom, printed it. And then last but not least, the court determined that there was harm to the market for these photos because this use was commercial and non-transformative. So they were probably going to be working in the same markets because if they wanted to, the plaintiff who owned those photos wanted to also put out their own book. Now they're competing with this person who's using their photos without permission. Another situation where there's not fair use is this great little pop-up in Houston that is no longer because they got shut down by Viacom. It was the Rusty Crab pop-up restaurant. It's like an experience where you get to be immersed in the SpongeBob, dining experience, kind of like the Krusty Krab from SpongeBob. They had the Rusty Crab. Viacom sued. They tried to argue that it was an immersive experience and that it was fair use because it wasn't exactly the same, of course, because, SpongeBob is a cartoon and this is like real life. Court said nope and considered it commercial use and not a parody because that was also one of the arguments they tried to make that it was a parody of SpongeBob, but you're using the actual, characters and elements from the show. SpongeBob is considered a fictional, imaginative work, so there's some creativity there. The immersive experience restaurant's use of these characters and show elements was pretty substantial because they were recreating a lot of it. And last but not least, the immersive experience based on SpongeBob did affect the potential market for Viacom, the owner of SpongeBob, to create or license derivative immersive works. So these people, the Houston pop-up restaurant, they were actually taking, you know, away the potential market share for Viacom to be able to create their own pop-up restaurants. This is one where I don't think people even realize that what you're doing is copyright infringement and could get taken down. So, this guy a few years ago, when Prince was, alive, went to a Prince concert and recorded a lot of the performances of Prince songs and recorded them on, of course, his camera phone, his iPhone. This was years ago, so probably, think about the quality was not exactly like the quality that we have now. He uploaded those recordings to YouTube, his own channel, and then, of course, Prince's estate found out about it and sued him for copyright infringement. The court determined that he did infringe and it was not fair use as he tried to argue because he felt like he wasn't making money from it, so it's not infringement. Um, why he tried to argue fair use is a mystery because really, like, none of this made sense on any level except for the fact that he probably just didn't see this coming. The court determined that it was commercial because even though he wasn't making money from it, he still posted it to his YouTube channel to gain subscribers and increase traffic to it. These are Prince songs, so they were highly creative works. He also put the whole video of the whole song on his YouTube channel, so he got the valuable portions of the song, which would be like all of it. And of course, these videos diverted traffic away from Prince's authorized YouTube channel, and that deprived the estate of ad revenue. So that meant that there was market harm. And the court also threw in another dig and basically said, like, these videos are trash. They don't even look like quality videos. So they're just, uh, uh, they're affecting the Prince market for this. So like they have to go. But there was fair use found in using the phrase party and bullshit in new songs. So, The Last Poets had a song years ago featuring the phrase party and bullshit toward the end of the song. As we know, the Notorious B.I.G., otherwise known as Biggie Smalls, had a song called Party and Bullshit on one of his mixtapes. It was one of his first songs, if not the first song that he came out with that, you know, a lot of people in New York and underground had first heard. Also, Rita Ora had a song called Party, where she also uses the phrase party and bullshit. The Last Poets copyright owner for the song sued the companies that are the owners of the copyright in the Biggie Smalls and Rita Ora songs. And the court determined that there was fair use. It determined that the songs transformed a purpose of the phrase from condemnation to glorification. Um, it was a different effect that they, provided. Like, they weren't the same. The phrase was considered a creative work, but it was also published, so it was already out in the public. uh, it was considered just to be one phrase from the original song and not critically important to the song's message. So there were other things in that song that made it, um, that completed its message and not just this one phrase. And then finally, the songs appeal to a different target audience. Like the audience for the Last Poets was, not considered the audience for Biggie Smalls or for Rita Ora's song. So they didn't substitute, this use of this one little phrase for the original work. Now, we're going to take a minute to see if this is going to work because this one is a wild situation. So I'm going to press play. All right. So what we have here is an image from Beyonce's Formation video where she's sitting on top of a New Orleans Police Department vehicle in a flood of water. And the voiceover at this point is from a New Orleans rapper known as Messy Mya. His real name is Anthony Barre, but he was kind of a well-known figure in New Orleans, giving commentary, doing a lot of videos, and like just you know real New Orleans. Like this is almost the definition of New Orleans for me. But Beyoncé featured some of his audio clips from those videos in her Formation video. And if you realize, if you go to if you have, iTunes or whatever streaming service, the Formation version of the song that you have is not going to be the same because Beyonce got sued by Anthony Barre's estate because Messy Mya was also murdered, unfortunately, in New Orleans, and m those videos were, registered as copyrights by his sister, and then all of a sudden, Beyoncé found them some kinda way, and they decided to use the clips. A lot of people thought these were Big Freedia's voice, but no, they are Messy Mya. Messy Mya's estate, along with his sister, who, was the executor of his estate, or I should say, let me back up. Messy Mya um, was a Black trans woman, but Anthony Barre is actually listed as the plaintiff, and the estate is listed under Anthony Barre. So I want to be respectful of that. Court determined that Beyoncé, this is just a preliminary finding, but there the court said that it was not fair use. It doesn't mean that necessarily this became an infringement claim. It just meant at the beginning stages of this case, the defense said that this was fair use, and the court said, no, it's not. The use of Messy Maya's voice in Formation was not fair use because it did not transform the audio clips, and it was for commercial use. It was a, song. The works were creative and published, so they were considered to be creative videos with, his voice or Messy Maya's voice. Um, the portions that were used in the Formation video and song were significant to the videos that Messy Maya did. And last but not least, the court actually did not make a determination on this, but I think they were leaning toward actually ruling in Beyonce's favor for this one factor, that the effect of the use on a potential market, the plaintiffs didn't make any allegation regarding the adverse effect on the market for the videos, like if they were going to license them or whatever. But in this case, they did have an opportunity to maybe make that argument in an amended complaint. But the three out of the four factors, the court determined this was not a fair use. All right. I hope you all got some information out of this and at least can get a better idea of what the fair use doctrine is as it relates to copyright infringement. Hopefully, you can make some better decisions based on this regarding how you are using other people's copyright protected work in your social media, especially if you're not taking the time to get permission, which you should be doing anyway, regardless if you think it is fair use, you should still get permission to use it or obtain a license. Um, so you can actually find the information about copyright at the copyright.gov website. They also have a host of other information, again, about, copyright, the law of copyright, what can be protected by copyright, how to register copyright. Also, they have a what's called a fair use index. So it is like copyright.gov/fair use, where they're talking about cases that have been decided whether or not, fair use applied or if it did. So very helpful in situations where you might have something similar and you're trying to decide, like, if I were to get sued, would this be something I would use? Like, if I got a cease and desist letter, could I make an argument in that letter for fair use? And it kind of just, this whole situation doesn't go where it could go. So check those out. And again, my name is Nicole Gaither. I'm a trademark copyright attorney with Sage House Legal. You can check us out at our website, sagehouselegal.com. And that is the end. Thank you for joining. And if you have any questions, please feel free to reach out and please follow our channel. Bye.